Good morning, everybody. We're making progress. We're somewhat closer together now. Hello, Senator Grassley. A little brief update, and we'll take up the business of the committee where we left it off. Next week, we're having an important hearing about policing, community policing, the use of force. We're going to have two panels. It'll be a long day. I hope it will be an informative day and hope some good will come out of it. Last time we talked about witnesses regarding inquiry to the Mueller investigation. To Senator Feinstein and our friends on the other side, I promise you that if you want to call Mr. Mueller or his designee, that's fine with me, the appropriate time. When the Flynn case is over, when that ever happens, I want the DOJ to come and tell us why they decided to drop it. And if you want to call Mr. Gleason or Judge Gleason or anybody else as to why it shouldn't have been dismissed, we will do that. I think that would be a good topic for this committee. So, having said that, the business before the committee was Senator Feinstein's amendment. Would you like to vote or talk, or what would you want to do?
I'd like to make opening
Yes,
statements
ma'am.
and move
Absolutely.
ahead.
And when she's done, if I could have a quick unanimous.
Yes, ma'am, I'm done. It's all it's yours. Yes, Senator Leahy, Senator Feinstein, Senator Leahy.
And a quick UC, Chairman, when she's done.
Absolutely.
Well, thanks, Mr. Chairman. It's my understanding that today we're resuming debate on the chair's resolution to grant himself unilateral subpoena authority. As I've noted in our earlier markups, this is really unprecedented, at least in my 26 years. The resolution would give the chair sole authority to issue literally hundreds of... I'd like to make opening statements.
Yes, ma'am.
And move ahead.
Absolutely.
And when she's done, if I could have a quick unanimous.
Yes, ma'am, I'm done. It's all it's yours. Yes, Senator Leahy, Senator Feinstein, Senator Leahy.
And a quick UC, Chairman, when she's done.
Absolutely.
Well, thanks, Mr. Chairman. It's my understanding that today we're resuming debate on the chair's resolution to grant himself unilateral subpoena authority. As I've noted in our earlier markups, this is really unprecedented, at least in my 26 years. The resolution would give the chair sole authority to issue literally hundreds of subpoenas without any agreement from the ranking member or any committee vote on any specific subpoena as required by committee rules. Simply put, if the resolution passes, it will remove any role of the minority in issuing a subpoena. Now, we've operated for, at least that I know of, 26 years. And it's come to, I really think that how the rules function on subpoenas is the right way. And so I would urge my colleagues to vote against the chair's resolution. We should operate under our existing rules. And this would allow the chair to issue subpoenas as he would want, either with the ranking member's agreement or by a committee vote. It's my understanding that my Republican colleagues likely will support the chair's subpoena resolution. And so last week, I offered an amendment. That amendment would grant the ranking member the same ability as the chair to issue subpoena on the topics listed in the chair's resolution. The committee debate on this amendment was pending when we ended the markup last week, so it'll be up for further debate and a vote today. And I'll have a few remarks when that time comes. I'd like to address the nomination of Corey Wilson to a Mississippi seat on the Fifth Circuit. And I will be opposing Judge Wilson's nomination, and I'd just like to briefly explain why. Judge Wilson has a record that, if you look at it, is really far outside of the mainstream on a number of critically important issues. He has expressed opposition to the rights of LGBTQ Americans. He's expressed opposition to women's reproductive rights, to workers' rights, and to common sense gun safety measures. He's also made clear his opposition to the Affordable Care Act, whose passage he called, quote, perverse and, quote, illegitimate. If Judge Wilson were to have his way, the ACA would have been struck down by the Supreme Court. This would be disastrous for the 20 million Americans who gained coverage thanks to the ACA, and for the estimated 129 million non-elderly Americans with a pre-existing condition who would be denied coverage if the law were to be repealed. It's hard, at least for me, to see how Judge Wilson could rule objectively on any case raising an issue of coverage under the Affordable Care Act. And this is particularly troubling right now when more than 112,000 Americans, it's just gone up from 110,000, 112,000 Americans have died from COVID-19, and minority communities have been hit particularly hard. He also opposes voting rights and has been a strong proponent of voter ID laws, claiming without any evidence that voter fraud happens, end quote, and that, quote, voter ID can work to help, end quote. And he has made demeaning statements about former Obama, calling him King Barack, petty and small, as in quotes, and, quote, a fit-throwing teenager, end quote. As of Tuesday, the committee had received 19 letters or statements of opposition to Judge Wilson's nomination from groups that include the NAACP Legal Defense and Education Fund, NARAL, and the Congressional Black Caucus. I would like, Mr. Chairman, to enter these letters into the record
Without
and
objection.
read from just a few. The Congressional Black Caucus writes, Judge Wilson has, and I quote, expressed more support for ultra-right-wing ideology than support for equal protection of the law, equal access to the ballot box, and established precedent in the area of civil rights, end quote. This led to the Congressional Black Caucus to conclude the following, and I quote, it should be clear that if Wilson is confirmed, he would not support and uphold laws that support inclusion, diversity, equal rights and protection, and other long-held civil rights protections so important to all Americans, but especially to African Americans, end quote. That's from a letter of opposition dated May 18th of this year. The Lawyers Committee for Civil Rights under Law notes the following in its letter, and I quote, Mr. Wilson's record advocating against voting rights and access to health care, as well as his expressions of racial hostility toward President Barack Obama, lead us to doubt his ability to serve as an impartial federal judge with an open mind on any civil rights issues impacting community of color. That's, end quote. That's from the Lawyers Committee for Civil Rights under Law, May 5 of this year. I will vote against Judge Wilson's nomination and urge my colleagues to do the same. Thank you very much, Mr. Chairman.
Senator Lee.
Thank you. Turn on. Is this on? Oh, okay, the light didn't work. Thank you, Mr. Chairman. I spoke on the subpoena issue last week. I'll keep my remarks today brief. I just note that earlier this week, several senators on this committee, led by Senators Booker and Harris, introduced legislation to reform the way our nation approaches policing. And I understand Senator Scott is working on his own reform bill on behalf of the Senate Republicans. I actually think this committee would be better serving the American people today if we were focused squarely on the issue of racial injustice. I know we have a hearing next week, but at this moment our country needs more than words. I think they need more than a single hearing. I hope this committee will focus its time and resources this summer on this issue. It's gripping the nation, desperate need of our attention. Now, specific to the subpoena authorization before us, I've stated before that I think it's a low for this committee. Even including the subpoena authorization I obtained 12 years ago in 2008, which sought a narrow set of torture-related documents. It came after 5 years of bipartisan efforts, and a number of Republican senators saying, go for it, we just don't want to be involved. Never before has the chairman of this committee sought a subpoena authorization without even attempting to work with a ranking member, and certainly not the 5 years I did on that. Never before has a chairman sought a subpoena authorization as a first resort, as opposed to a last resort. Never has a chairman sought a limitless authorization to subpoena what could be hundreds of individuals and millions of pages of documents. And I don't think any one of us with a straight face could say the members of this committee are going to sit and read millions of pages of documents. And never has a chairman devoted the full weight of this committee's resources to pursue a wholly partisan investigation after being prompted by a presidential campaign. Now, the chairman last week stated this investigation is not linked to broader bipartisan efforts to reform our surveillance laws. And I don't doubt the chairman's word on that. And I do not think anybody really reasonably believes this investigation will uncover abuses or errors relevant to FISA authorities that were not already uncovered during the Inspector General's exhaustive investigation and 478-page report, which many of us have read. But the fact is, according to President Trump, the two issues are linked. Due to his apparent confusion about what has already been uncovered by the Inspector General and how this body already came together to fix it, President Trump does not want to sign a FISA reform bill until investigations into 2016 have concluded. So the House Republicans who had said they would support the bipartisan bill that passed the Senate, when they got that tweet from the president, suddenly reversed course and withheld their support for the Senate-passed FISA bill. Now, whether we like it or not, it appears so long as the chairman is conducting this sprawling investigation, critical FISA reforms, overwhelmingly approved by Republicans and Democrats alike in the Senate, are on hold. That means that some non-controversial, important surveillance authorities, such as Lone Wolf and roving wiretap that many of us have discussed, remain unauthorized. Now, no matter whether you think this investigation is purely political or not, it's a problem that because of it, we say, well, we can't go forward with the FISA improvements that Republicans and Democrats in the Senate overwhelmingly approved. And I'll support Senator Feinstein and my other fellow Democratic senators as they offer amendments to make the subpoena authorization more balanced and more likely to result in a fair investigation. But I firmly believe the committee has better things to do today, so I want the chairman to know, I know this will come as a great surprise to him, that I will vote no on his authorization. And I'll put into the record, if I might, my statement regarding Corey Wilson, and it strongly supports what Senator Feinstein has said.
Thanks, Senator Lee.
But I do ask permission to put that.
Absolutely, without objection.
Mr. Chairman, could you clarify, are we now considering the Feinstein amendment to your subpoena
Yes, sir.
amendment?
Yes, sir.
Is that correct? And then Judge Wilson, or
We'll do him after the subpoena
after the
vote.
subpoena. I have a series of amendments I would like to offer
Absolutely.
after Senator Feinstein is
We'll
considered.
address them in due course. Senator Whitehouse.
I've said my piece the last time we were together, so I'm not going to repeat myself, but since then, Judge Gleason's brief in the Flynn matter has come out, and I'd like to ask unanimous consent that that document be made a part of the record of this proceeding, with particular attention to pages 3 to 17, where he describes the underlying conduct of General Flynn.
Yeah, without objection, and I told the committee before, I don't know if you're here, Senator Whitehouse, I'm very interested in the Flynn case. I think everybody over here is, and y'all are too, and that's a good thing to, so DOJ, when we get a resolution, Senator Whitehouse, I'm gonna call them in. Why did you drop this case? What made you believe you needed to change course? And if you'd like to call Mr. Gleason or anyone else to say it shouldn't have been, we'll do that. And I think that would be good for the country. Senator.
Okay. Thank you, Mr. Chairman. And I want to join Senator Feinstein in her opposition to these subpoenas, as well as opposition to this judge. I'll put my statements on the record. But since you raised the hearing that we will be having, which I'm glad we're having next week, I want to bring the committee's attention to a letter that was sent yesterday to DOJ Inspector General Michael Horowitz. I have the letter here, and I'd like to enter it on the record. Put on the record, thank you. This letter is from more than 1,200 former Justice Department officials across the country. It calls on the Inspector General to investigate Attorney General Barr's role in the decision to use force, including tear gas and rubber bullets, against peaceful protesters in Lafayette Square near the White House. These protesters were there to draw attention to the police killing of George Floyd in my state, and to demand justice and an end to police use of excessive force against black men and women in this country. I think we all know this is an issue of critical importance, every single senator in this room. And as I said, I'm glad that the committee will be holding a hearing next Tuesday on the issue of police use of force. It's an important first step. Yesterday, the ranking member, Senator Feinstein, joined by all of us on this side of the aisle, sent you a letter, Mr. Chairman, asking that Attorney General Barr be called to testify at this upcoming hearing. It is inconceivable that we would move forward without hearing from him. After all, it is the Attorney General who sets Justice Department policy and oversees multiple law enforcement agencies. He is the chief law enforcement officer of this country. So either at this hearing or a hearing next week involving simply him, I believe we need to hear from him. Among other things, the committee needs to hear from the Attorney General about why the Justice Department appears to have abandoned pattern and practice cases to examine systematic racial discrimination in policing, including the use of force. During the Obama administration, there were 25 of these pattern and practice investigations, colleagues, that were brought. This weekend, after I led a letter with my colleague Senator Smith and 26 other senators asking for a pattern and practice investigation of the Minneapolis police, Attorney General Barr was on Face the Nation. And when asked specifically about this, he said that he didn't think it was necessarily warranted in this case. Colleagues, if it is not warranted in the case, in the video that you saw in Minneapolis, to have a pattern and practice investigation of this police department, what facts would warrant such an investigation? This Trump administration Justice Department has undertaken only one investigation like this, and it was a unit of the Springfield, Massachusetts Police Department. That's it. So I ask you to join us in asking the Attorney General when and where and why we would ever have a pattern practice investigation if he does not believe that it is justified in this case. We await a formal answer from him, but for now, all I have is what he said on a national news program.
And
It is also essential, I'll finish quickly, that the committee hold an additional separate hearing with Attorney General Barr to examine the Justice Department's response to the protests that I raised and is raised in the letter from the DOJ officials. Attorney General Barr was at the center of the decision to remove peaceful protesters from the Lafayette Square using tear gas and rubber bullets in order for the president to have, as we know, eventually a photo op in front of the church waving a Bible. Inspector General Horowitz should open an investigation, but it is also the responsibility of this committee to examine the federal government's response to protesters, as well as the deployment of federal law enforcement in Washington, D.C., and the treatment of journalists covering the protests. Thank you, Mr. Chairman.
Thank you. Senator Coons.
Mr. Chairman, if I might, I'd like to make just an opening statement about today and about the subpoena vote we are about to take, and brief remarks about Judge Wilson and his candidacy, so that I'll make no further comments other than voting. Thank you, Mr. Chairman. As we all know, we are in a truly difficult, challenging, and demanding moment for our nation with three different epidemics. I've spent the last few weeks listening to Delawareans and Americans expressing righteous anger over the brutal killing of George Floyd, people who are challenging our government to finally recognize and remedy systemic racism that's pervaded our justice system and other aspects of our nation for far too long. The COVID-19 pandemic has also laid bare inequities in our healthcare system and our economy that have gone unaddressed for too long. And I've listened to small business owners and other individuals in my state suffering from the effects of the worst health and economic crises of our lifetimes. In this context, I appreciate this committee will hold a hearing on policing on Tuesday and hope we can explore meaningful ways we can work together to respond to the epidemic of racism that is so foundational to our modern challenges. This committee is at its best when we work in a bipartisan fashion to meet the demands of our constituents and provide leadership in difficult moments like this. I fear today's actions deviate from that responsibility. Mr. Chairman, I deeply appreciate and respect that you and I work together in a bipartisan fashion to ensure Special Counsel Mueller could complete his investigation without interference. And I appreciate then Chairman Grassley's willingness to move that bill through this committee. We have disagreements over the ultimate outcome of that investigation, but it shows we can work together on difficult and divisive issues. And it's that kind of bipartisan cooperation I wish we were seeking today. Instead, we forge ahead with a subpoena authorization to reopen investigation I think has been exhaustively investigated. Rule 9 is clear. A subpoena is issued either by agreement with the ranking member or a vote of the committee on each subpoena. In my view, the Department of Justice Inspector General has already completed a 19-month investigation into the origins of the Russia investigation that culminated with a more than 400-page report validating the investigation and concluding it was properly predicated. It found no evidence political bias led to the FBI's investigation and found nothing to contradict the 37 indictments, guilty pleas, and convictions produced by it. The report did find evidence of gravely concerning inaccuracies represented to the court in the FISA process for Carter Page. But this problem is not unique to the Russia investigation. An audit released by the IG in March shows these defects are all too common across FISA matters. We should fix this broken system. And if the committee would like to focus on FISA reform, I would welcome that work and that conversation. Sadly, that's not what we're doing today. This authorization won't fix flaws in the FISA system and will not overturn the results of the Russia investigation or change the IG's conclusions. Briefly, Mr. Chairman, if I might speak to Corey Wilson and his record, I believe his statements to be demonstrations of extreme partisanship that make it clear he's unfit for the bench. His statements go well beyond mere disagreement. I understand a Republican president will nominate candidates with different political views than mine, but he's written that an intellectually honest Democrat is a rare sighting, that those who agree with him are real Americans and that others are not, and that 20% of the population identifying as liberal has been, and I'm cleaning this up, shoveling chicken feed to the rest. Comments like these show to me a temperament that should have no place in our judiciary. He's also expressed a repeated desire to see the Affordable Care Act repealed and denied that restrictive voting laws lead to voter suppression. Given this and many other concerns, I will today be voting no. Thank you for your forbearance and giving me the opportunity to make an opening statement, Mr. Chairman.
Absolutely. Senator Blumenthal.
Mr. Chairman, thank you for hearing us out in this meeting and for scheduling a hearing next week on police practices, which really should be our priority at this moment. On the nomination of Corey Wilson to be a judge on one of our most distinguished court of appeals, not only is he unqualified by virtue of experience and other qualifications, but he's been a steadfast opponent of the Affordable Care Act at a time when we really need to be strengthening our health care system, not decimating it, at exactly the time when a stronger health care system is necessary to combat the ongoing pandemic. Corey Wilson would decimate it. In fact, he regrets that it, quote, retains an air of illegitimacy, end quote. He believes that it will, quote, fall of its own weight, end quote, and if it doesn't, he will do everything he can to destroy it. On the issue of the subpoenas, all I can say is that literally this country is at a moment of reckoning. We are at a time when the nation is demanding revolutionary change in our police practices to heighten justice and eliminate racism. It is a classic opportunity for this committee to lead. I hope the hearing next week will be a beginning, but life is a matter of priorities. And if we devote our attention to this investigation involving the subpoena that the chairman is asking to do today and the power to issue those subpoenas, we are going to distract ourselves from that obligation and opportunity to really reform our criminal justice system and eliminate racism, to make police forces around the country more professional and to improve their training and recruiting practices. I recognize that Senator Scott has yet to issue anything on paper, but that should not prevent us from moving forward right now at this moment to provide leadership on the Judiciary Committee, the place where that leadership traditionally has come from. If the focus is on FISA reform, this subpoena list in no way reflects that goal. If it is on relitigating the Mueller report, the Inspector General has put to rest the key questions that may be raised. He has said that nothing in his report casts doubt on any part of the Mueller report's basic findings. That point was repeated in the testimony that we took from Rod Rosenstein at the first of our hearings on this topic, and it will be repeated throughout our hearings. Nothing we find as a result of this investigation will go farther than the Inspector General's report, and nothing there casts doubt on the ultimate findings and conclusions of the Mueller investigation. So I ask that we focus on the real task at hand, not just the pandemic, the health crisis, and the economic crisis where we can play a part, but on the reform to our law enforcement structure that is so vital. And I will have a series of amendments, as will a number of my colleagues, to your amendment, Mr. Chairman. Thank you.
Senator Hirono?
Thank you, Mr. Chairman. I will be supporting Senator Feinstein's amendment, but I would like to speak to your motion. Sorry. Can you hear me now? Okay. It's on now. I would like to speak to your subpoena motion, Mr. Chairman. Our country is facing three crises: a health pandemic, an economic catastrophe, and systemic racism and police violence. But rather than doing something concrete about these crises, this committee is asking for blanket subpoena authority to go over ground that has already been covered. In addition, the committee has spent the past 2 months ramming through two anti-health nominees, Justin Walker and today Corey Wilson. Both are totally against the Affordable Care Act, and don't tell me that they are suddenly going to change their views on the subject, especially from the safety of their lifetime appointments to the federal bench. Each will have decades on the bench to push their ideological ideas. The logic of the Republican Party's obsession with eliminating the ACA can only be explained by the fact that they see no problem with kicking millions of Americans off their health care in the middle of a pandemic. For the past 2 weeks, this committee has devoted countless hours to chase after a conspiracy theory to undermine the FBI's investigation of the Trump campaign ties to the Russian government. President Trump has been desperately pushing this conspiracy theory in the hope that it will distract the American public from his failures, from the fact that he has failed to provide any form of effective leadership to guide this country through a deadly pandemic, that he has attacked peaceful protesters with tear gas ordered by his Attorney General Barr so that he could get a photo op in front of a church, that he has threatened to use our military not to protect Americans, but to dominate them as they peacefully protest against systemic injustice and racism. That he has falsely accused a 75-year-old peaceful protester of essentially deserving to be knocked on the ground by police where he lay bleeding from his head. Clearly, the president needs this committee's help. And by this motion, this committee is giving it by abusing its power. What this committee is asking us to do is no different than the abuse of power that former Judge Gleason identified in his scathing brief filed yesterday in the Michael Flynn case. He pointed out that the Department of Justice had, quote, abdicated its responsibility through a gross abuse of prosecutorial power to provide special treatment to a favored friend and political ally of the president, end quote. Furthering Trump's conspiracy theories is not the job of the Senate Judiciary Committee. Last week, the chair kept talking about the FISA court's stunning rebuke of the FBI as the basis for asking this committee for unilateral subpoena powers. After the OIG report, the FISA court issued a public order directing DOJ to report how it intends to ensure that the FBI's FISA applications are complete and accurate. It was a rare rebuke. But the chair also repeatedly stated last week that we're not trying to fix FISA, which is what one would think would be the focus and interest of this committee. What we're actually doing is undermining the investigation of the Trump's campaign ties to Russian election interference. As stated previously, this ground has been covered before by the Mueller investigation and by IG Horowitz report, both of which were nearly 500 pages each. So while millions of Americans are unemployed, millions are lining up for food, some waiting for hours, and millions more children are going hungry in Trump's America, this committee wants to waste taxpayer money chasing the president's conspiracy theories. Even if this committee spent a fraction of the money that House Republicans did in investigating Hillary Clinton, we're still talking hundreds of thousands of dollars. After spending nearly $7 million of taxpayers' money over 26 months, the House Select Committee on Benghazi, led by Republicans hell-bent on finding something to blame on Hillary Clinton, found no evidence of wrongdoing by her. Is this the path this committee is on, Mr. Chairman? Wasting taxpayers' money? Let's be clear what today's vote is about. It's about subpoenaing 53 individuals named in the subpoena authorization request, in addition to anyone identified in Inspector General Horowitz's report involving more than 100 witnesses and anyone involved in the Crossfire Hurricane investigation. Are we going to tell the American people how much time and money will be spent going down this rabbit hole to help the president? I strongly object to the subpoena motion and will not support it. I have some comments regarding Corey Wilson that I will hold until we get to his nomination. Thank you, Mr. Chairman.
Yes, ma'am. Senator Booker.
Mr. Chairman, I have a lot of well-written words here that I'd love to submit for the record and spare my colleagues them. But I do want to appeal to you as a chairman and as a friend. There were a lot of really well-said words, passion on both sides about the investigation that you said is going to get done no matter what. And there were constitutional principles that were talked about, and FISA abuses, FBI abuses, a lot of things for what happened over a year ago that we want to investigate. And so that's obviously going forward. No eloquence from our side of the aisle will stop that. I guess what I want to appeal to you is apply that same standard to something that is more immediate and I think urgent. And my words probably are not as compelling as the words of some of the most respected generals in our country right now, who have been speaking towards what happened in Lafayette Park and speaking to it as if it is a constitutional stress test. Now, you've been very sympathetic and to work with me on another moment where I thought it could be a constitutional stress test when I was worried about the firing of Mueller. And you spoke last week and recognized even then that, hey, I get it, and I'll sit down and work with you on something. And so now we have in Lafayette Park, which is a really sacred area. The first protest in front of the White House was done by a woman named Alice Paul, I'm proud to say she's from New Jersey, who was a suffragette who was arrested in front of the White House for protesting peacefully. She went on a hunger strike, and they forced tubes in her throat, assaulted her constitutional rights, and I think tortured her. But since then, we've evolved to that space being really sacred. It's a space where people come and protest Democratic presidents, Republican presidents. You see Second Amendment rights protesters, so-called right-to-life protesters. I love coming to the Capitol because this is sacred ground where people come to peacefully protest, which is one of the most sacrosanct constitutional principles, I believe, in the right to petition your government, the right to peacefully protest. And what we saw in Lafayette Park under this president was an affront to those ideals and principles. And don't take my word for it. We could go through the numbers of people that are folks that are respected on both sides of the aisle who are now saying that. And so my concern is if we in this committee, who applying the standard I heard defended last week, the standard that you and I have worked together on, Mr. Chairman, nobly, I would say, that this is a moment that we are facing a constitutional stress test yet again. And to not question that, to not have a hearing on it, to be silent when this makes me worry about what I think the next 150 days in America are going to be. And people can say I'm alarmist, but I really worry that we are heading into a serious constitutional stress test for this country with deeper divides, that we could possibly find ourselves with mass protests in November on the streets. I don't know where they might come from, and I'm not saying this is probable. I'm saying that I am worried that we could be heading into a moment in American history where, as Judge Learned Hand talked about, that the ideals and principles that are written on these sacred documents are only as good as the people's commitment to them. And so this is the first warning, so to speak, of a constitutional stress test. A president that did things that I know in good faith shocked the consciousness of people on both sides of the aisle in this institution. And where we hear people like General Mattis coming out with grave warnings about the Constitution and our principles. And I think it could be a precursor to a very difficult time in America. And if we do not stop and pause here as a committee and hold some kind of hearing, I don't care if it's a discussion amongst all of us in a room with nobody else around, I think we have failed at a very important moment in American history to speak up, to use our wisdom as was envisioned by the founders, that this Senate would be a cooling place for sober reflection and introspection, a deliberative body that would look at a time. Because if we fail right now, we will tumble further to what I believe could be a very challenging time where all of us will be called not to act as politicians, but as patriots to defend the principles and ideals of this country against the passions or demagoguery of others. Thank you.
Thank you. Senator Harris.
Thank you, Mr. Chairman. I have a brief statement about Judge Wilson. This week, Senator Booker and I introduced the Justice and Policing Act, as has been mentioned, with more than 200 co-sponsors from the United States Senate and the United States House. This is a sweeping and comprehensive bill that would improve our ability to hold police accountable for unlawful killings. On Tuesday, George Floyd was laid to rest in Houston, Texas, after, of course, he was murdered by the police in Minnesota. This committee should honor his memory and recognize the significance of his death by taking up the Justice and Policing Act. But instead, this committee is advancing a judicial nominee with an anti-civil rights record. His record, in fact, is an antithesis to what the American people are marching for and demanding right now. Judge Wilson has a long history of hostility to voting rights in Mississippi. In 2011, Judge Wilson dismissed concerns from a member of the Mississippi chapter of the NAACP that a voter ID law would suppress the vote as, quote, poppycock, unless you count the dead vote. In June 2013, Judge Wilson described former Attorney General Holder as, quote, whining that voter ID laws are part of an illegitimate, orchestrated effort by Republicans to suppress poor and minority voting. This record is extremely problematic at this moment in time, especially when then, just given this week, we saw voter suppression in the state of Georgia, including limited ballots, voting machines down, and hours-long lines in primarily Black and brown communities. So, Mr. Chairman, Judge Corey Wilson should not be confirmed to this judicial vacancy at this moment in our history. And as the NAACP wrote in its letter of opposition, it would be a particular affront to the people of Mississippi, a population that has 38% African Americans, to have Judge Wilson preside over voting rights cases in that state. I will vote no on his nomination today. Thank you.
Thank you all. Senator Feinstein, you wanted to say something else?
You know, nobody knows who's going to be minority and who's going to be majority next year. And this amendment would add a single phrase to the end of the fourth line. The phrase would read, authorizes its ranking member after consulting the chairman to issue subpoenas. This would give the minority the opportunity, if there is a controversial hearing, to see that they have a chance to present their case by subpoenaing a witness. If you don't grant this, you're going to skew future hearings. And it's very concerning to me. We could be in the majority. I wouldn't want to do that to the minority. I think you want to hear both sides in a hearing. And so there are no names mentioned into it. It's just a simple amendment. And I think it's a really basic fairness. Otherwise, you give total control to the majority, and the minority cannot subpoena a witness.
Mr. Chairman.
My case rests.
Mr. Chairman.
Yes.
Could I just ask, as a matter of clarification, I know we're talking about subpoenas, which are ordinarily used for witnesses who don't voluntarily appear. But nothing we're doing today changes the Judiciary Committee rules, which entitle the minority to have witnesses during a hearing as well, do they? Or does this?
No.
So any hearing we may have involving a subpoenaed witness would also have, the minority would have a right to call on a voluntary basis any witness that they choose, right?
Yeah, and if they needed somebody subpoenaed, I would work with Senator Feinstein to see if we could accommodate. So let's thank you all for.
May I respond to that?
Yes, ma'am.
But here's the problem. If something comes up and the minority wants to call a witness, the minority should be able to call a witness. This would prevent that because the majority would have the sole power, and who knows what happens in the future. I mean, this doesn't affect the present, but it affects the future.
Well, Senator, if I can just say, I don't think that's correct. I think we're just talking about subpoenaing witnesses. We're not talking about the right of the minority understanding Judiciary Committee rules to have a
You're right. It is a
witness.
subpoena.
And so they could certainly appear on a voluntary basis. And the chairman said he would work with you to subpoena them if that were necessary. So,
Yes.
Mr.
If
Chairman.
I could, I know we all have got other things to do, but this is really important for me. I appreciate everybody having their say about Judge Wilson, and I'll talk about him in a bit. So I find myself in a position where I think we need to look long and hard how the Mueller investigation got off the rails. You may not be interested, but I want to know why Mr. Barnett on January the 4th at the FBI field office said, let's drop Flynn from Crossfire Hurricane. and why Strzok said, no, the seventh floor wants to keep it going. You may not be interested, but I want to know why Sally Yates didn't know that Flynn was being surveilled by the outgoing administration, and he's the National Security Advisor designee for the incoming administration. Horowitz did a great job, but he didn't answer basic questions. Senator Hawley, very exasperated, said, Rosenstein, who do we blame? Senator Kennedy said, are we going to blame this on some junior G-men or junior G-women? Here's what none of you can answer. When the Russian subsource came into the FBI in January and submitted to a 3-day interview, he also was interviewed in March and May. This was the man who provided all the information to Christopher Steele that resulted in the now Steele dossier that was outcome determinative in getting a warrant against Carter Page, an American citizen associated with the Trump campaign. This committee is not going to sit on the sidelines and move on. I want to know, to those 4 people who interviewed the subsource in January, did you tell anybody? Because you had a duty to the court. If you don't believe me, listen to the court. The FBI's handling the Carter Page applications, as portrayed in the OIG report, was antithetical to the heightened duty of candor described above. The frequency with which representations made by the FBI personnel turned out to be unsupported or contradicted by information in their possession in which they withheld information detrimental to their case calls into question whether the FBI contained in other FBI applications is reliable. Horowitz looked at the lack of Woods procedure in other FISA applications, but we're talking about altering an email here and consciously withholding exculpatory information from the court. You are going to have a hard time convincing me that these 4 people sat in interviews for days and found out their case crumbled and never told anybody. Maybe that's true. If that's true, they need to be fired. They need to be disciplined. But anybody that was told about the unreliability of the dossier and continued to use it, they're good candidates to go to jail or lose their job. And nobody on this committee can answer that question, because the warrant application with Carter Page was renewed in April and June, months after the underlying document necessary to get the warrant had completely collapsed. We're going to find out about that. And if there's nothing there, then I'll have egg on my face. But I'm going to promise the American people we're going to get to why everybody ran stop signs all the time. And maybe it's 4 people in the bottom of the basement. Maybe not. But we'll soon find out. As to the process here, it's clear to me y'all have a different view of this. We had a unanimity, not unanimity, we had bipartisanship that Mueller should be able to look at what happened. There seems to be no desire to look at how Mueller got so off script. We're going to look at it. Mr. Horowitz did a good job, but he didn't answer any of the questions that I'm talking about, so we'll get those answers. As to the device I'm using, I went to the toolbox and found a situation where Senator Lee gave unto himself the powers I'm trying to give unto me. And here's what happened. You used it, not in a bad way. Every Republican voted against it, but I think you sort of worked your way through the problem. And I've just told my friends on the other side, you want to know why the Flynn case was dropped? I do too. Was it for political reasons? I don't know. We'll hear the DOJ's explanation. We'll hear from Mr. Gleason. If you want somebody to come in and tell us that the Mueller report was all up and up and this is just a bunch of nothing, you can call Mr. Mueller, you can call his designee. I have no desire to deny you a chance to tell the other side of the story, but I am very intent on making sure this never happens again. Because if it can happen to a Republican, it can happen to a Democrat.
The Senator, if I might be allowed to speak for a moment, the Senator has mentioned me. I would point out again that the subpoena I issued was a very limited amount. We had 5 years of negotiation on it. There was quiet acknowledgement by a number of Republicans, including the then ranking member, that go ahead and do it. We're not going to raise any more questions. It was a very limited in scope, and it was on torture. And it was a question on torture that everybody in the Senate wanted to know. I also know we keep talking about the surveillance of Flynn. Am I mistaken when I read that the surveillance was of the Russian ambassador Kislyak? And in that surveillance of Kislyak, Flynn was seen, but that was because they were surveilling Kislyak. And it became an issue after General Flynn lied to Vice President Pence, as noted by many in the White House. He lied to Vice President Pence about those meetings, and that sort of led to a number of things. But the surveillance was of Ambassador Kislyak. I'm not going to go into some of the classified matters, but the chairman is aware of them. But am I not correct that the surveillance, and this has been stated publicly, so it's not.
You're correct that the intercept was based on surveilling Mr. Kislyak, but there was a counterintelligence investigation opened up against General Flynn back in 2016. And in January the 4th, all the experts recommended dropping General Flynn from Crossfire Hurricane, but he was kept in the investigation because of the 7th floor. So he was actually being surveilled all the way back to 2016, suspected of working with the Russians during the Trump campaign. The FBI made a decision January the 4th. The experts, the frontline field agents said there's no there there, but they kept going. That's what I want to get.
Did he lie to Vice President Pence?
You know, we'll figure all that out here.
And Mr. Chairman, I will say, actually, Senator Leahy, I think, raises a good question. It has been reported the intercept was on Kislyak, but we haven't heard testimony in this committee on that. And one question that I asked Mr. Rosenstein last week that I didn't get a straight answer to is whether the FBI was surveilling and intercepting General Flynn's communications. And I will say from what's public, there is an inference one can draw, because we do know from the unmaskings that have been released that there was not an unmasking request for the particular conversation that became the subject of all the controversy. I think December 26th, if I'm remembering the date correctly. Had it been a surveillance of Kislyak, then Flynn's name would have been redacted and required an unmasking. There was not an unmasking request for that conversation. That raises the inference that this was an FBI intercept and not a CIA intercept, and that Flynn was the target. We don't know that because nobody has answered that question, but I think Senator Leahy does a good job of pointing out the sorts of questions this committee needs to get an answer to. Was the Obama administration deliberately surveilling, intercepting the communications of, and targeting a three-star general, retired, and the incoming national security advisor of the incoming president?
Mr. Chairman?
Yes, sir.
Did he lie to Vice President Pence?
Yeah.
If I can go back to process just for a moment, and in response to Senator Cornyn's point and your answer to it, first of all, I appreciate very much that the Judiciary Committee tradition of a minority witness at a hearing will be honored. Thank you. That is good. But when you're dealing with an issue like this, in which witness preparation and investigation are important, it's also important whether the subpoena process that you are imposing on this committee today is also going to be treated fairly. Let's say a witness is subpoenaed. Will the minority be present for witness interviews? Will the minority be able to see documents that are provided pursuant to subpoenas?
Yeah, I can answer
Will we
yes
be
to
assured,
both.
let me just
Absolutely.
finish. Will we be assured that no member or no staff member of this committee will be communicating and engaging with the Trump campaign about the direction of this? Can we be assured that documents and witnesses that are provided pursuant to the subpoena are not going to be provided to the Trump campaign during the... There's some pretty basic guidelines that I think need to be nailed down. My letter to you, I think, nailed down a lot of those questions. That has not been answered. I think it would be reassuring to me to know that no member of this committee is going to be in communication with the Trump campaign and wheeling and dealing with them about this investigation, and that we'll have equal rights when witnesses are provided, we'll have equal rights when documents are provided, there will not be back channels with the Trump campaign or the Trump White House. That's basic, I think, legislative investigative number Rules 101, and that's where I think we need to really nail this down.
Well, so nobody asked me or when I supported the Mueller investigation, these questions.
Well, we
I
didn't
can
control
assure
the Mueller
you-
investigation.
Right. I assure you, we're not going to be deterred. If we have to do it by ourselves, we'll do it by ourselves. But we're going to get questions answered like Senator Cruz asked. I want to know why all these counterintelligence investigations were opened to begin with, and why every time they should have stopped, they continued. And somebody needs to be held accountable for what happened here. And we're going to be in the accountability business. Attorney General Barr will come before this committee, and he will testify about his job as Attorney General as part of oversight. You can ask him about anything you want to ask him about. But we're going to go forward. It is clear to me I have to do this way. If I want to get to the bottom of what happened, I regret it, but we are where we are. And I promise you, you will have your say in an appropriate fashion. So the clerk will call the roll on this
Well,
Feinstein
Mr.
amendment.
Chairman, if I may, for a moment before the roll,
Yes, ma'am.
surprised by this, because this ties the hands of the minority in any serious investigation. They do not have the authority to subpoena a witness. And I never thought we'd reach this.
Well, it'd be a collaborative process, but you're trying to stop me from doing something I think the country needs to do, and I'm not going to be stopped, and we're not going to move on. The clerk will call the roll.
Mr. Grassley?
No.
Mr. Corman?
No by proxy.
No by proxy.
Mr. Lee? Mr. Lee? No. Mr. Cruz? No. Mr. Sass? No. Mr. Hawley? No. Mr. Tillis? No. Ms. Ernst? No. Mr. Crapo? Mr. Kennedy? No. Mrs. Blackburn? No. Mrs. Feinstein?
I,
It's not agreed to,
Mr. Leahy?
ask if anyone wants to offer
Mr.
another.
Durbin? Mr. Whitehouse?
Aye.
Ms. Klobuchar?
Aye.
Mr. Coombs?
Aye.
Mr. Blumenthal?
Aye.
Ms. Hirono? Mr. Booker? Ms. Harris?
Aye.
Mr. Chairman?
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment is not agreed to. The other amendment, Senator Durbin.
Mr. Chairman, I call up Amendment HEN 20547.
Clerk will distribute the amendment.
I think it's available for distribution. Is it?
It's already circulated
I think
electronically.
we have it electronically.
It's been distributed? Good. This amendment expresses the sense of the committee regarding the constitutional rights of American citizens to peaceably assemble.
So you need to
On June the 1st, we witnessed an extraordinary and outrageous act here in our nation's capital.
Okay.
Federal law enforcement attacked peaceful demonstrators outside the White House. Some say it was tear gas, others say pepper gas, but they were gassed and rubber bullets were shot at them at the direction of Attorney General William Barr. According to press reports, the assault began with law enforcement kneeling, not to express solidarity with anti-racism efforts, as we've seen with some police officers around the country. They were kneeling to put on gas masks to protect themselves from the weapons they were about to fire at peaceful demonstrators. As soon as that was done, the president marched from the White House across Lafayette Square to St. John's Episcopal Church. The Attorney General, the Secretary of Defense, and the Chairman of the Joint Chiefs of Staff all followed. It was a rare display of the might of the American government. What was the battleground that drew this show of force? The gathering, the peaceful gathering of Americans raising their voices, asking this country to stop racism. Unfortunately, these peaceful demonstrators got in the way, in the path of the president on his way to a photo op. Attorney General Barr said he wanted to, quote, dominate the streets, close quote, and he redirected personnel from the FBI, the Bureau of Prisons, the U.S. Marshal Service, the ATF, ICE, the Border Patrol, TSA, and other agencies away from their normal duties to participate in this attack on Lafayette Square. Listen to what former Defense Secretary Jim Mattis said about this action. Quote, "We know we are better than the abuse of executive authority that we witnessed in Lafayette Square. We must reject and hold accountable those in office who would make a mockery of our Constitution." At this critical moment in our nation's history, one would expect the United States Senate Judiciary Committee to consider this measure, to stand up and speak up, to exercise our oversight duties over the Attorney General and the Department of Justice, to examine why lawful protesters engaged in their First Amendment rights were attacked by federal law enforcement officers, to discuss the pervasive systemic racism, the incidents of police brutality, and the ongoing fight in this country for civil rights. These issues go to the heart of this committee's jurisdiction. Instead, as we've learned, the chairman and majority are determined that this historic, distinguished committee will instead focus on the Mueller investigation into Russia's 2016 election interference. The streets of America and the world are afire, figuratively, with the passion people feel for justice. We are in the midst of a pandemic. We know full well the state of the economy. And yet, we are going to do the bidding of the president to consider an issue which may be of some value to him in his reelection campaign. Mr. Chairman, it's time to get back to basics. You said yourself, someone needs to be held accountable. I offer this amendment to your motion in the hope that we can return to the conversation and the committee's attention to the very real issues our country is facing. At the very least, we should go on record in defense of the constitutional rights of all Americans to peaceably assemble and express our disapproval with Attorney General Barr's actions.
Thank you. Anyone else? I will move to table because it's not related to the underlying subject matter. We will have hearings about race and justice and the conduct of the department about a variety of things in due course, but I move to table. The clerk will call the roll. Yeah.
Can I make a real brief comment?
Absolutely.
Senator Durbin, the substance on Lafayette Park I agree with. The move to condemn the Attorney General before we know what we don't know, I think is too much. So I'll vote with the chairman, but the substance on Lafayette, I agree with you. Thanks.
Clerk, call the roll.
Mr. Grassley. Aye. Mr. Corning.
Aye by proxy.
Clarification, motion to table?
Yes.
Yes.
Mr. Lee. Aye. Mr. Cruz. Aye. Mr. Sachs. Aye. Mr. Hawley. Aye. Mr. Tillis. Aye. Ms. Ernst. Aye. Mr. Crapo. Aye. Mr. Kennedy. Mrs. Blackburn. Aye. Mrs. Feinstein.
No.
Mr. Leahy. No. Mr. Durbin.
No.
Mr. Whitehouse. No. Ms. Klobuchar.
No.
Mr. Coons.
No by proxy.
Mr. Blumenthal. No. Ms. Hirono. No. Mr. Booker. No. Ms. Harris. No. Mr. Chairman. Aye. Mr. Chairman, the votes are 12 yeas, 10 nays.
The amendment is tabled. Any other amendments?
Mr. Chairman?
Senator Durbin.
I don't know if any of the other members have amendments. I have 7 amendments, and I defer to others who would like to, may wish to offer amendments so that I don't own the
Absolutely.
floor.
Senator Hirano.
Where is my amendment?
White House wants one, too.
Yeah.
I'd like to call up HEN 20519.
Without objection, distribute the amendment.
So, Mr. Chairman, this amendment
Thank you.
is to have this committee hear from Jared Kushner. And so if this committee is serious about understanding the Crossfire Hurricane investigation and Russia's interference in our 2016 election, we need to hear from him. We know that he was involved in a June 9th, 2016 meeting at Trump Tower where he and Donald Trump Jr. met with a Russian attorney expecting to receive political dirt on Hillary Clinton from the Russian government as, quote, part of Russia and its government's support for Mr. Trump, end quote. In 2017, this committee, in a bipartisan effort with then Chairman Grassley and Ranking Member Feinstein, tried to obtain a voluntary interview with Jared Kushner, but he refused. The committee sought transcribed interviews, emails from WikiLeaks, and documents about a, quote, Russian backdoor overture and dinner invite, end quote, but Jared Kushner refused to turn over those documents. My amendment would aim to finish what this committee sought to do in 2017. It would require a subpoena to be issued to obtain documents and testimony from Jared Kushner. I ask for a roll call vote on this amendment.
Thank you. Senator Grassley, I think.
Yeah, I would like to give some rebuttal to some of the things that's been said based upon some of the stuff I've been involved in that have involved subpoenas. I've long supported Congress's constitutional mandate to conduct oversight under administrations of both parties and including through this committee. I voted with Senator Specter to support various subpoenas issued by this committee during the investigation of the firings of several U.S. attorneys during the Bush administration. I even supported the committee's contempt resolution against 2 of its witnesses. So I will support this authorization so that the chairman can effectively continue his oversight. And I think my remarks also apply to the amendment by Senator Hirano. I'd like to remind my colleagues that during my time as chairman, the committee investigated alleged collusion between the Trump campaign and the Russians. This included a careful examination of the events surrounding the June 9th, 2016 meeting at Trump Tower. Committee staff interviewed 5 individuals who participated in that meeting, including the president's son, 4 individuals with ties to Russia, and collected documents from several others involved. At the ranking member's request, the committee interviewed an additional 6 individuals and reviewed nearly 1,000 pages of additional documents that they provided. This group included advisors to the Trump campaign and the transition team, as well as a business associate of the president. I subpoenaed Paul Manafort with the ranking member Feinstein's agreement to appear at a hearing and provide testimony. Instead of publicly testifying, Manafort voluntarily agreed to an interview with my and ranking member Feinstein's staff. But the ranking member's staff then refused to interview him and objected to my staff doing so without them. After pressing so forcefully, ranking member Feinstein changed her position and wanted to release Manafort from a hearing subpoena and invitation on the eve of the hearing. So we did not interview Manafort. On March 2018, I made 2,500 pages of transcripts, written statements, and exhibits from the committee's Trump Tower investigation available to the public. The committee also reviewed records from Manafort, Michael Cohen, and Kushner, nearly 5,000 pages of documents produced by the Trump Organization and the president's son, over 30,000 pages of documents supplied by the Trump campaign, and 180,000 pages from the transition team. The committee has never received any emails from the Democratic National Committee or the Clinton campaign, even though we repeatedly asked for them. Of course, the ranking member wouldn't support subpoenas of those. The ranking member also didn't support a subpoena for Fusion GPS records. We received tens of thousands of blank pages and unresponsive material from Fusion. The only way to get compliance was through a subpoena, which never happened. Staff did receive multiple briefings from technology companies pertaining to the Russian influence campaign and received tens of thousands of pages of related material that they supplied. During the course of its Russia investigation, the committee also held a hearing on Foreign Agents Registration Act oversight, submitted countless oversight requests to federal agencies and the special counsel's office, and reviewed sensitive and classified documents produced by the State Department, Justice Department, FBI, and intelligence community. We didn't find a single shred of evidence to support Russia collusion narrative. We found quite a lot of evidence that there were problems with the way that the FBI conducted its investigation, and that's based on roughly 4 years of work. So that's why, that's where the unanswered questions still are, and I'm glad that the focus we're now taking is very legitimate and right. As far as I'm concerned, this subpoena authorization is ripe for a vote. However, during the course of the inquiry, we found the only real collusion that took place was between the Democratic National Committee, Clinton campaigns, and Russian officials. The DNC and the Clinton campaign hired Fusion GPS, which in turn hired Christopher Steele. Steele created his dossier, which was based in part on Russian government sources connected to the Russian presidential administration. Some of those sources supported Clinton. Based on declassified footnotes from the Inspector General's report, the intelligence reports indicate that information contained within the dossier was the product of Russian disinformation. That begs the question then, what did the Clinton campaign know about the dossier, and when did they know it? Or better yet, what did Hillary Clinton know about the dossier, and when did she know it? My Democrat colleagues don't seem to interested in finding answers to those questions, even though the Steele dossier is the only real evidence of Russian collusion with the presidential campaign, and it happens to be the Clinton campaign. In conclusion, I'd like to insert into the record a complaint filed by the nonpartisan Campaign Legal Center before the Federal Elections Commission. The complaint states that the DNC and the Clinton campaign wrongfully reported millions of dollars in payments to law firm Perkins Cooley and legal services when some of those payments were actually for Fusion GPS and their opposition work with Steele against Trump. As I'm sure you all will recall, Mark Alias, one of Clinton's lawyers, publicly denied any involvement with the Steele dossier, which was false. We now know he made sure Fusion's and Steele's work continued in order to undermine Trump, and it certainly looks like the other side wants to do everything it can to not get that information out.
Thank you. The clerk will call the roll on the Hirono Amendment.
Mr. Grassley?
No.
Mr. Cornyn?
No by proxy.
Mr. Lee? No. Mr. Cruz? No. Mr. Sacks? No. Mr. Hawley? No. Mr. Tilley? Ms. Ernst? No. No, I think yours might go first. Mr. Kennedy? No. Mrs. Blackburn? No. Mrs. Feinstein?
Aye.
Mr. Leahy? Aye. Mr. Durbin?
Aye.
Mr. Whitehouse?
Aye.
Ms. Klobuchar?
Aye.
Mr. Coons?
Aye.
Mr. Blumenthal?
Oh, aye by proxy, excuse me.
Ms. Corona?
Aye.
Mr. Booker?
Aye.
Ms. Harris?
Aye.
Mr. Chairman? No. Mr. Chairman, the vote is 10 yeas, 12 nays.
The amendment's not agreed to. Senator Whitehouse.
Mr. Chairman, I'm going to call up, but not ask for a vote on Amendment SIL 20661, just to reinforce my point made at the last meeting about the selective enthusiasm of this committee for getting to the bottom of things and what appears to be a policy at the Department of Justice of refusing to answer committee members' letters and committee members' questions for the record. That is a policy at the department that appears to have been bipartisan in nature, and that Republican senators' questions were ignored, as well as Democratic senators' questions. I went through with Mr. Rosenstein at the hearing we had, I think 17 hearings to which we had no QFR responses. A lot of these were pretty touchy things, like the apparently fake tip line that the FBI set up in the Kavanaugh hearings but refused to look at any results from. So I think there's a lot that's of interest here, and I had asked for subpoena authority to pursue where there were letters unanswered and where there were QFRs unanswered, the answers to those unanswered letters and QFRs. As a result of the conversation that we had in the committee, the chairman has graciously agreed to meet with the Deputy Attorney General and myself to go through this sad litany of unanswered questions, to try to figure out where the policy came from not to answer them, and to embark on a process for getting answers to those unanswered questions, whether by letter or QFR. Given the status of that and given the chairman's accommodation, I'm not going to seek a vote on this right now, but if that process breaks down, Mr. Chairman, if we get told to go pound sand by the Deputy Attorney General, if the FBI and the Department of Justice continue their policy of non-responsiveness and ignoring answers and continue to throw this committee's questions into a bin someplace at the department or at the FBI, then I intend to raise it again and pursue this further, and I appreciate the chairman's support so far for this inquiry.
Absolutely. Senator Coons, Blumenthal. Senator Coons, okay, Coons.
Thank you, Mr. Chairman. I call up Amendment HEN 20514 relating to Paul Manafort. As I've made clear, I think this investigation isn't this committee's most urgent priority at a time when we're facing 3 other national crises. And if we're going to conduct an investigation a year after the Mueller report concluded and 6 months after the IG report, I think we should examine all the facts. So I'm moving an amendment to subpoena Paul Manafort, who was the campaign chairman when Crossfire Hurricane investigation was opened. He was the Trump campaign chairman with a long history of working with Russian-connected oligarchs and politicians. Despite having considerable debts to oligarchs and being out of national politics for years, Mr. Manafort volunteered to work for the campaign of then-candidate Trump for free. And then he and his deputy, Rick Gates, regularly provided internal Trump campaign polling data to Konstantin Kilimnik, a Russian national with ties to Russian intelligence, with the expectation the data would be shared with oligarch Oleg Deripaska, who's allied closely with Putin. During an August 2nd, 2016 dinner, Manafort briefed Kilimnik on the state of the Trump campaign and his plan to win the election, including discussing battleground states, which Manafort identified later as Michigan, Wisconsin, Pennsylvania, and Minnesota. Manafort also took part in the June 9, 2016 Trump Tower meeting, in which Russian representatives offered to provide incriminating documents on Secretary Clinton. Manafort was investigated, convicted, pled guilty to multiple felony accounts, including lying to investigators about his interactions with Kilimnik and defrauding American taxpayers. He is currently serving out his prison sentence in home confinement. He was subpoenaed by this committee in 2017, but did not appear due to his pending indictment. Now that his criminal cases have run their course, we should hear from him as well as a part of this investigation. I am confident we could arrange for the production of relevant documents and provision of sworn testimony, even while Mr. Manafort serves out his term in home confinement. So I encourage my colleagues to support this amendment. Thank you, Mr. Chairman.
I refer to what Senator Grassley said
Mr.
about
Chairman?
Mr. Manafort. Yes, ma'am.
On the amendment, as I understand it, the committee has never heard from Manafort, who had numerous contacts with individuals linked to the Russian government, including Kilimnik, who has ties to Russian intelligence, and an oligarch, Oleg Deripaska, with ties to Putin. While he was leading the Trump campaign, Manafort lied to the special counsel's office and took steps to conceal evidence, leaving unanswered questions about his conduct that we believe the committee should explore. If we go back to the Russia investigation, I think it's our view that all people who have relevant information should be heard.
He didn't work for the FBI, Department of Justice, so clerk will call the roll.
This is it.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Serrano.
Aye.
Mr. Booker.
Aye.
Ms. Harris.
Aye.
Mr. Chairman. No. Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment is not agreed to. I think Senator Blumenthal, then I'll get you Senator Klobuchar and Durbin. You have more, right? Okay, Senator Blumenthal.
Thanks, Mr. Chairman. There are a few individuals whose testimony would be more relevant to this so-called investigation than Rudy Giuliani. I'd like to call up Amendment HEN 20523, which would require a subpoena for Mr. Giuliani. He was a campaign surrogate in 2016. He became the president's personal lawyer, but any privilege has been long ago waived. He has a lot of information, some of it he's made public, a lot of it not, that could bear light on this investigation. I can go into details on what he has said publicly, but I'm going to avoid it in the interest of time and simply move the amendment. I also wish to be recorded as an aye on the previous vote as if I were president on the Hirono vote,
Thank you.
Hirono amendment.
Without
And
objection.
I move Amendment HEN 20523, asking for Rudy Giuliani to be subpoenaed.
Thank you. I would urge my colleagues to say no, because that's not what we're looking into. Mr. Grassley. Clerk will call the roll.
Mr. Grassley.
No.
Mr. Cornyn.
No by proxy.
Mr. Lee. No. Mr. Cruz. No. Mr. Sachs. No. Mr. Hawley. No. Mr. Phillips. No. Ms. Ernst. No. Mr. Trayka. No. Mr. Kennedy. No. Mrs. Blackburn. No. Mrs. Feinstein.
Well, they're on this committee.
Is it me? Oh, excuse me. Aye.
Mr. Leahy. Mr. Durbin.
Aye by proxy. Oh, excuse me, he's here. It's White House.
Mr. Whitehouse. Aye. Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Serrano.
Aye.
Mr. Booker.
Aye by proxy.
Ms. Harris.
Aye.
Mr. Chairman.
No. Coming and leaving out of the room.
Yeah.
10 yeas, 12 nays.
The amendment's not agreed to. Klobuchar.
Mr. Chairman, just trying to. Yeah, stopped working. Here we go. Mr. Chairman, I'd like to offer my amendment, HEN 20521. This amendment will authorize and direct the chairman, after consulting with the ranking member, to issue a subpoena for documents and communications and testimony from Konstantin Kilimnik. If this committee is truly going to investigate the people who were doing their jobs to protect our national security, then we should also hear from the Russians who were in the middle of Russia's interactions with the Trump campaign. From the special counsel's report, Kilimnik is a Russian national who worked with Paul Manafort in Ukraine. That is volume 1, page 129 of the report. And according to the FBI, he has ties to Russian intelligence. That's page 133 of volume 1 of the report. According to the special counsel's investigation, Paul Manafort and Rick Gates regularly provided internal Trump campaign polling data with Kilimnik, with the exception that the data should be shared with Oleg Deripaska, an oligarch allied with Vladimir Putin. And on August 2nd, 2016, Manafort and Kilimnik had dinner where they discussed, and I take this from volume 1, page 140 of the report, quote, battleground states, which Manafort identified as Michigan, Wisconsin, Pennsylvania, and Minnesota. That would be my home state. And when it is your state and you hear these guys are talking about this to Russian intelligence, people with ties to Russian intelligence, yeah, you get pretty concerned. Kalimnik was indicted by the special counsel for obstruction of justice, but the special counsel wasn't able to gather evidence on what Kalimnik did with the polling data. You don't have to be from my state or from Michigan or Wisconsin or Pennsylvania to want to get to the bottom of what happened. I think the least we could do as part of any further investigation into the 2016 election and into our country's interference, what happened to the interference in our election, the least we can do is hear from this witness. I hope all of my colleagues will support this amendment, and I ask for a roll call vote.
And I'll refer to what Senator Grassley said about the committee's activities looking at Russia, and I would urge a no vote. Clerk, call the roll.
Mr. Grassley?
No.
Mr. Cornyn? No by proxy. Mr. Lee? No. Mr. Cruz? No. Mr. Stack? No. Mr. Hawley? No. Mr. Phillips? No by proxy. Ms. Ernst? No. Mr. Crapo? No. Mr. Kennedy? No. Mrs. Blackburn? No. Mrs. Feinstein?
Aye.
Mr. Leahy?
Aye.
Mr. Durbin? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar?
Aye.
Mr. Coon?
Aye.
Mr. Blumenthal?
Aye.
Mr. Rono?
Aye.
Mr. Booker?
Aye.
Ms. Harris? Aye. Mr. Chairman?
No.
Mr. Chairman, the vote is 10 yeas, 12 nays.
The amendment is not agreed to. Senator Durbin.
Mr. Chairman, I call up Amendment HN 20516. This amendment authorizes and directs the chairman, after consulting with the ranking member, to issue a subpoena for documents, communications, and testimony from Michael Cohen regarding the matters in the chairman's investigation. 2016, Cohen was vice president in the Trump organization and a personal attorney to candidate Trump. Cohen was heavily involved in the efforts to build a Trump Tower in Moscow, for which candidate Trump had signed a letter of intent in the fall of 2015. According to the Mueller report, from September 2015 to June 2016, Cohen pursued the Trump Tower Moscow project on behalf of the Trump organization and had briefed candidate Trump on the project numerous times. That statement to be found in Volume 2, page 6 of the Mueller report. In January 2016, Cohen communicated with the office of Dmitry Peskov, Putin's Deputy Chief of Staff and Press Secretary, regarding the Trump Tower Moscow project. Also, according to the Mueller report, quote, during the summer of 2016, Cohen recalled that candidate Trump publicly claimed that he had nothing to do with Russia, and then shortly afterwards privately checked with Cohen about the status of the Trump Tower Moscow project. Mueller report, Volume 2, page 137. Mr. Cohen has pled guilty to fraud, to making false statements to Congress about the duration and extent of his work on the Trump Tower Moscow project. He's currently serving his sentence in home confinement, but we could certainly seek his testimony, even remotely. I believe if this committee is going to reinvestigate whether Crossfire Hurricane and the Mueller investigation were factually predicated, why would you not call Michael Cohen? Remember what the Attorney General said about the Mueller report and the investigation? Utterly baseless, his words, utterly baseless. We have given you opportunities and will continue to this morning to bring in relevant witnesses. The fact that you are turning down every single relevant witness tells us and tells the world this is an irrelevant investigation. It is not relevant to the issues of the moment, and it certainly isn't relevant when it comes to calling material witnesses, which any normal prosecutor would call. This is stacked, my friends. You get a chance now to bring in Michael Cohen and learn what the Moscow project for Donald Trump was all about. I ask everyone to vote aye.
For 2.5 years, this country went through a deep experience regarding the 2016 presidential campaign on the Trump side. Hundreds of subpoenas, hundreds of witnesses, bipartisan support to let the job be done. The job was done. Now we're going to look at how it got off the rails. I'd urge a no vote, Senator Grassley.
Mr. Grassley? No. Mr. Cornyn? Mr. Lee? No. Mr. Cruz? No. Mr. Stack?
No by proxy.
Ms. Ernst? No. Mr. Franco? Mr. Kennedy? No. Mrs. Blackburn? No. Mrs. Feinstein?
Aye.
Mr. Leahy? Aye. Mr. Durbin?
Aye.
Mr. Whitehouse?
You need that vote.
Mr. Whitehouse?
Did he vote?
Sorry, aye by proxy.
Oh, aye by proxy?
Ms. Klobuchar?
Aye.
Mr. Coons?
Aye.
Mr. Blumenthal?
Aye.
Mr. Rono?
Aye.
Mr. Booker?
Aye.
Ms. Harris?
Aye.
Mr. Chairman?
No.
Mr. Chairman, the votes of 10 yeas, 12 nays.
The amendment fails. Senator Durbin, I think Senator Harris, do you have an amendment? Do you mind if we go to her? Then
No,
we'll come
please.
back to you.
Thank you, Mr. Chairman and Senator Durbin. I'd like to offer amendment number HEN 20552, an amendment to the subpoena authorization. Mr. Chairman, I'd like to speak on the amendment on behalf of myself and Senator Booker. As has been mentioned many times, there were peaceful demonstrators who gathered in front of the White House on June 1st to protest the murder of George Floyd and were violently forced out of that area by federal law enforcement. It was subsequently reported that Attorney General Barr personally ordered their forceful removal. Of course, the protection of civil rights and liberties falls squarely within this committee's jurisdiction. It is therefore absolutely essential that we investigate the Attorney General's role and reasons for authorizing the use of force against Americans exercising their First Amendment rights, which is why, on behalf of myself and Senator Booker, I'm offering this amendment that the chairman may not issue any subpoenas under the authority of this motion until the committee has conducted a hearing to examine the conduct of Attorney General Barr on June 1st, 2020. And I think bears note that Secretary of Defense Mattis last week in reaction to that incident said, quote, "We must reject and hold accountable those in office who would make a mockery of our Constitution." Chairman Graham, I request a roll call on my amendment.
Yes,
Thank
ma'am.
you.
And I would say the committee is moving forward in a reasoned manner, given the Mueller report, and we're going to have a
Louder,
hearing
please, Mr. Chairman.
next week about the problems facing the country. So, do you have something, ma'am?
I wanted you to speak louder.
Oh, I'm sorry. I oppose the amendment by tabling because it's not relevant. So the clerk call the roll on the motion to table.
No.
No.
Aye.
Yes.
Throw you a loop, sorry
I'll go
about
with your
that.
first response.
Aye by proxy.
Mr. Lee? Aye. Mr. Cruz? Mr. Staff? Mr. Hawley? Mr. Tillis? Ms. Ernst? Mr. Crapo? Mr. Kennedy? Mrs. Blackburn? Mrs. Feinstein?
No.
Mr. Leahy? No. Mr. Durbin? Mr. Whitehouse?
No.
Ms. Klobuchar?
No.
Mr. Coons?
No.
Mr. Blumenthal?
No.
Ms. Rono?
No.
Mr. Booker?
No.
Ms. Harris?
No.
Mr. Chairman?
Aye.
Mr. Chairman, the votes are 12 yeas, 10 nays.
The amendment is tabled. Senator Durbin.
Mr. Chairman, for the sake of the committee, I only have 5 more requests for relevant witnesses the majority doesn't want to hear from. I will try to move with dispatch on each one.
Do you want to do them all together?
No, I don't.
Okay.
HEN 20518, thank you, Mr. Chairman. The amendment authorizes and directs the chairman, after consulting with the ranking member, to issue a subpoena for documents, communications, and testimony from Rick Gates regarding the matters in the chairman's investigation. Mr. Gates was the Trump campaign deputy chairman and longtime associate of Paul Manafort, another person you don't want to hear from. According to the Mueller report, quote, Manafort instructed Rick Gates, his deputy on the campaign and a longtime employee, to provide Kalimnik, whom we've heard about before, with updates on the Trump campaign, including internal polling data. Volume 1, page 129, Mueller report. Gates did so on numerous occasions. This report notes that, quote, Gates suspected that Kalimnik was a spy, a view he shared with Manafort. Volume 1, page 134, Mueller report. Kalimnik refers to Konstantin Kalimnik, we've heard about, a Russian national who worked with Paul Manafort in Ukraine and who the FBI assessed to have ties with Russian intelligence. The Mueller report also includes a heavily redacted section discussing communications between candidate Trump and Gates about releases by WikiLeaks, including a conversation in which the report says, quote, Trump told Gates that more releases of damaging information would be coming. You can find that statement, Volume 1, page 54, Mueller report. Gates was indicted, pled guilty to make false statements and conspiracy against the United States. I believe if this committee is going to reinvestigate whether Crossfire Hurricane and the Mueller investigation were factually predicated, we naturally would like to hear from a relevant witness like Mr. Gates.
Yeah, I oppose the amendment. Clerk, call the roll. No.
No.
No by proxy. No by proxy.
Aye.
Mr. Leahy. Mr. Durbin.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal. Ms. Hirono.
Aye.
Mr. Booker.
Aye.
Ms. Harris. Mr. Chairman.
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment's not agreed to. Senator Durbin.
Amendment HGN 20548, George Papadopoulos. The amendment authorizes and directs the chairman, after consulting with the ranking member, to issue a subpoena for documents, communications, and testimony from George Papadopoulos regarding the matters in the chairman's investigation. Papadopoulos was a foreign policy advisor to the Trump campaign in 2016. The Mueller report discusses how Papadopoulos was told on April 25, 2016, by Joseph Massoud, a London-based professor with Russian ties, that the Russian government had obtained dirt on Clinton in the form of thousands of emails. Mueller Report, Volume 1, pages 80 to 95. Papadopoulos mentioned this to Australian officials on May 6, 2016, and they contacted the FBI in July 2016, prompting the FBI to open its counterintelligence investigation on July 31, 2016. Mueller Report, Volume 1, pages 81 and 1. According to the Mueller Report, during a March 31, 2016 Trump campaign meeting, Papadopoulos, quote, told the group that he had learned through his contacts in London that Putin wanted to meet with candidate Trump and that these connections could help arrange the meeting. Mueller Report, Volume 1, page 86. According to the Mueller Report, several witnesses at that meeting, quote, stated that Trump was interested and receptive to the idea of meeting with Putin. Mueller Report, Volume 1, page 86. Papadopoulos worked for several months with Mifsud and two Russian nationals to arrange a meeting between the Trump campaign and the Russian government, though the meeting did not take place. Mueller Report, Volume 1, page 6. Papadopoulos pled guilty to making false statements to the FBI about his contact with Mifsud, and he has completed his sentence. If this committee truly wants to investigate whether Crossfire Hurricane and the Mueller investigation were factually predicated as opposed to some cooked in-house political job, why wouldn't you call a relevant witness like Mr. Papadopoulos?
Mr.
For
Chairman.
2.5 years, excuse me if I may respond first. For 2.5 years, Mr. Mueller and his team looked at everything and everybody. Not one person has been prosecuted from the Trump world for colluding with the Russians. Mr. Papadopoulos got a 2-week sentence about misstating, allegedly lying about when he met a particular person. Yes.
You know, if we're going to have a hearing, we have to be allowed to produce evidence. As I understand this, George Papadopoulos was a member of the Trump campaign. In July of 2016, he told an Australian official that the Russians had dirt on Hillary Clinton in the form of thousands of emails, and that they were willing to release these emails to help Trump and hurt Clinton. Australia shared this information with the FBI, which opened Crossfire Hurricane based on it. There are significant questions outstanding about how Papadopoulos learned that the Russians had Hillary Clinton's emails. So, you know, why wouldn't you want the committee to have access to this information in order to see the full extent surrounding the opening of Crossfire Hurricane? If we're going to do investigations, we have to allow people to bring in evidence. I don't understand why people would vote no on this. Thank you.
Well, I appreciate that, and I told you We'll have Mr. Mueller or a designee come into the committee at the appropriate time to talk about the investigation. But I want to make this really clear. All these people we're talking about had their lives turned upside down, being surveilled by their own government, on tape saying, I didn't work with any Russians, I didn't collude with the Russians, it'd be treason. So we're going to get to the system that led to all this. Mr. Mueller had plenty of time to look at these people, and we're going to start looking at the people who did the investigation. The clerk will call the roll.
No. I believe so.
No by proxy.
There's the Stone, the Coon Stone amendment left, and the Sessions amendment from Blumenthal. They're not offering.
Aye.
Those are the only other ones that are remaining.
Aye. Ask him if they're.
Aye.
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 The amendment's not agreed to. Senator Durbin, how many more do you have, just for the information for the committee here? Timing?
I believe I have 2 left.
Okay.
Yes.
Senator
There
Durbin.
are a couple others that have been,
Okay.
maybe 3.
Okay, Senator Durbin.
Amendment HEN 20520, Michael Flynn. This amendment authorized directs the chairman, after consulting with the ranking member, to issue a subpoena for documents, communications, and testimony from Michael Flynn. General Flynn was a Trump campaign advisor in 2016, later became National Security Advisor for a brief period from January and February of 2017. In addition to his communications with the Russians during the transition, which he lied about and pled guilty to, the Mueller report discusses how after Trump had publicly invited Russia to find Hillary Clinton's deleted emails on July 27, 2016, quote, Flynn contacted multiple people in an effort to obtain the emails. Remember that? Trump said publicly that I invite the Russians to go looking for Hillary's emails, and General Flynn believed him. Flynn's contacts included Republican fundraiser Peter Smith, who claimed he was in contact with Russian hackers regarding the email. Mr. Smith committed suicide in May of 2017. Flynn has pled guilty to making false statements not once but twice regarding his communications with Russian Ambassador Kislyak during the transition period. Controversially, the Justice Department has tried to drop its prosecution, and as we all know, the matter is currently pending before D.C. District Judge Emmett Sullivan. We've talked so many times about whether General Flynn was treated properly. Why wouldn't we want him before the Senate Judiciary Committee under oath to tell his story? If this committee is truly going to reinvestigate whether Crossfire Hurricane and the Mueller investigation were factually predicated, they should hear from Michael Flynn.
I oppose the amendment. The clerk will call the roll.
Mr. Chairman, I'd just like to,
Yes,
I
ma'am.
see what's happening here. You can have an investigation, but you won't call the witnesses. Michael Flynn was Trump's national security advisor in January and February of 2017. Later that year, he pleaded guilty to lying to the FBI about his interactions with the Russian ambassador. Last month, the Justice Department moved to dismiss his case, despite overwhelming evidence that Flynn did knowingly mislead the FBI. Why wouldn't we want him to come before a committee if we're going to do an investigation and clear this up one way or another?
We will hear from the Department of Justice about their decision. You can call any witness you would like to say that it was inappropriate. That's what the committee will do regarding General Flynn. Opposed amendment, the clerk will call the roll.
Mr. Grassley.
No.
Mr. Cornyn.
No by proxy.
Mr. Lee. No. Mr. Cruz. No. Mr. Sachs. No. Mr. Hawley.
No by proxy.
Mr. Tillich.
No by proxy.
Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. No. Mrs. Feinstein.
Aye.
Mr. Leahy. Mr. Durbin.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Kuhn.
Aye.
Mr. Blumenthal. Mr. Rono. Mr. Booker. Ms. Harris.
Aye.
Mr. Chairman.
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment's not agreed to. Senator Durbin.
Mr. Chairman, Amendment HEN 20525, Jerome Corsi. The amendment authorizes and directs the chairman, after consulting with the ranking member, to issue a subpoena for documents, communications, and testimony from Jerome Corsi. In 2016, Corsi worked for the media outlet World Net Daily and was an associate of Roger Stone. Most of the information in the Mueller report about Corsi is redacted, but the Mueller report says that Corsi, a political commentator affiliated with the Trump campaign, quote, was involved in efforts to coordinate with WikiLeaks and Assange. Volume 2, page 128 of the Mueller report. Corsi has confirmed that he was person one in Roger Stone's indictment. The indictment discusses communications between Corsi and Stone discussing planned WikiLeaks email releases. I believe if this committee is truly going to have an honest investigation and reinvestigate whether Crossfire Hurricane and the Mueller report were factually predicated, we should hear from Mr. Corsi.
Mr. Chairman, if I may,
Yes, ma'am.
I think Senator Durbin is absolutely correct. I don't understand how we can do an investigation if you're not going to be able to get any of the evidence. And this allows the chairman, or urges the chairman, or directs the chairman, after consulting with the ranking member, to issue a subpoena for documents and communications and testimony at a hearing or deposition related to any aforementioned matter from Jerome Corsi. I don't understand why the other side would want an investigation and yet prevent the acquisition of material.
With all due respect, I don't understand why we would want to do the Mueller investigation all over again after we spent 2.5 years and $25 million doing it. I'm sorry it didn't turn out the way people like, but it's behind us. Now we're going to look at what happened and the misconduct involved and hold people accountable. Clerk will call the roll.
No. Mr. Cornyn?
No by proxy.
Mr. Lee? No. Mr. Drew? No. Mr. Sack?
No by proxy.
Mr. Hawley?
No by proxy.
Mr. Chilish?
No by proxy.
Ms. Ern? No. Mr. Cravo? Mr. Kennedy? Mrs. Blackburn? No. Mrs. Feinstein?
Aye.
Mr. Leahy? Aye. Mr. Durbin?
Aye.
Mr. Whitehouse?
Aye.
Ms. Klobuchar?
Aye.
Mr. Coon?
Aye.
Mr. Blumenthal? Aye. Ms. Hirono? Mr. Booker? Ms. Harris?
Aye.
Mr. Chairman?
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment is not agreed to.
Mr. Chairman?
Yes, sir.
My last amendment of relevant witnesses the committee does not want to hear from relates HEN 20524 to Roger Stone. This amendment would authorize and direct the chairman to subpoena Roger Stone in addition to the 53 names already on the chairman's list. Stone, of course, is well known, an advisor to the Trump campaign in 2016 and a longtime associate of Paul Manafort. Much of the information in the Mueller report about Stone is redacted, but his contacts during the campaign with WikiLeaks and Russian intelligence from Guccifer 2.0 have been widely reported. Stone was convicted in 2019 of witness tampering and lying to Congress. He's expected to report to prison at the end of June. I want to go back to the point made repeatedly by Senator Feinstein. If this is on the up and up, if this is legit, you bring in witnesses who are relevant. You decide whether their testimony is credible. You put it into the record so we have a complete record. For those who agree or disagree with the investigation, you give them each an equal opportunity to come forward and produce evidence that's relevant to the investigation. To say that the investigation of Crossfire Hurricane is really the center of this, and then to ignore every predicate that led up to this investigation, is frankly to call into question whether this is a credible exercise. At one point, when we brought the name Paul Manafort before the committee, the chairman said, and I quote, he wasn't an FBI agent. If that's the standard, you're not going to have 53 witnesses. There are many people on this chairman's list that are not FBI agents. Take a look. So I would ask that Roger Stone be brought before this committee, or at least be subject to subpoena for documents and information.
Senator Feinstein, would you like to say something?
Mr. Chairman,
Turn it on.
Mike?
I don't know how we can have an investigation and not allow the collection of applicable materials. And that's exactly what Senator Durbin is asking for. The committee never interviewed or received documents from Stone, who is a key figure in the Russia investigation. Special Counsel Mueller found that Stone sought out advanced knowledge of WikiLeaks' plans to release Hillary Clinton's emails and briefed Trump on what he learned. If Chair Graham is going to insist on revisiting, the committee should hear from all individuals with relevant information. Clearly, this is relevant. If you don't allow it, you stack the hearing. I don't understand what's happening. Senator Durbin's motions are all valid. And you can be for hearing and then stop any witness from testifying. That appears to be what's going on, Senator. I'm sorry.
From my point of view, it appears that you want to talk about everything except what we should be talking about. Mr. Mueller had carte blanche authority to look at everything you've talked about, Mr. Stone, and not one person has been prosecuted for colluding with the Russians. But Comey and McCabe and that whole crowd, their day is coming. Did you know the Russian subsource disavowed the dossier? How could you not have known? What kind of system do we have at the FBI? When the most high-profile investigation of a sitting president, what kind of system is there over there regarding investigations? How could it be possible that the people at the bottom of the basement told the case fell apart and people at the top have no idea? I don't buy that for one bit. Nobody's looked at this, but we're going to look. And we're going to go wherever the evidence takes us. Maybe it's just a system where nobody's paying attention to anything. I don't know, but I doubt it.
Mr.
I
Chairman?
oppose the request. The clerk will call the roll.
Mr. Chairman?
Yes.
Before we call the roll, if I could just say that the chairman and members on the Republican side have put at issue whether there was legitimate predication for this investigation. You've suggested that because there were errors and omissions found by Inspector General Horowitz in the warrants, that they would never have otherwise issued. And the question of whether there was adequate predication is one that you have put at issue here.
Yeah.
And if we're going to be creating a narrative here that there was no adequate predication, that this whole thing would have fallen apart completely once the warrant applications were corrected, which is what I've pursued warrant applications before. I've done wiretaps. I've been the chief law enforcement officer in my state federally. I've been the chief law enforcement officer in my state as a matter of state practice. And if I had a warrant application that contained either a false statement or material omission, what I would do, and what every responsible prosecutor would do, is send it back and get it corrected. You don't end the investigation because you get a bad warrant application. So the question of whether this was predicated is alive and well in this investigation. And the witnesses that Senator Durbin is proposing are witnesses who could support the fact that there was, in fact, predication for this investigation. And if what we're going to be doing is building a narrative that this investigation should have stopped dead as soon as the warrants went in that were wrong, as soon as Rosenstein, had he found out about it, that there should have been no Russia collusion investigation, despite all of the findings in the Mueller report that there was, in fact, Russian activity, Russian influence in this election, then we're on a very different course than if we're actually trying to get to the bottom of this. And I would submit that where your concerns and our concerns overlap is in the repeated Republican assertions that there wasn't predication to pursue the question of Russian influence. And that's why I think these are important. I just want to make that point clear.
No, I understand.
We're speaking kind of across each other, but there is a point where they overlap. And that is, was there or was there not predication to continue even if the warrant applications had been corrected?
Sure. No, I agree. And
Okay,
so
thanks.
here's the
That's all.
point. That's why we're going to call somebody from the Mueller team. You come here and justify your work product. How did the situation evolve the way it did? Why did you think these people were working with the Russians to begin with? How did you miss all this stuff? Why did you run stop signs? That's very fair. They'll come. I welcome somebody from the Mueller team to come. I welcome Mr. Mueller. If he can't come, I welcome Wiseman. I am not afraid to talk to the Mueller people about what they did. I think we should. So the clerk will call the roll.
No.
No by proxy. No by proxy. No by proxy.
Aye.
Mr. Leahy. Mr. Durbin.
Aye.
Mr. Whitehouse.
I'm not gonna be here.
Aye.
Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Mr. Rono. Mr. Booker. Ms. Harris.
Aye.
Mr. Chairman.
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment is not agreed to. Senator Blumenthal.
Well, they're strangling the.
Thanks, Mr. Chairman. I actually have two amendments that I think maybe we can agree on. The chairman's subpoena would include two former attorneys general, Lynch and Yates, and one present attorney general. Missing is a former attorney general who certainly has relevant knowledge, Jeff Sessions. In fact, if you look at the reasons for his recusing himself, it was because he might have some relevant involvement in the discussions that led to, in part, Crossfire Hurricane. In fact, on July 31, 2016, the day the FBI opened Crossfire Hurricane, he told CNN that the investigation should look at 30,000 emails that were in the possession of the Russians. Quote, they're the ones who have them, end quote. He is discussed in the Mueller report in regard to his seeking to arrange a meeting between Trump and Putin. That's in volume 1, page 86. Also mentioned are his contacts with the Russians during the campaign, including multiple meetings with Ambassador Kislyak and Dmitry Sims. That's at volume 1, pages 103 to 108. I ask that Amendment HEN 20522 be called, which would direct the chairman to include Jeff Sessions in his subpoena.
Thank you. I respectfully disagree with the request for former Attorney General Sessions. Clerk will call the roll.
No.
No by proxy. No by proxy. No by proxy. Yeah.
Voted no. Voted no? Yep. Mrs. Blackburn.
Aye.
Mrs. Blackburn. Mrs. Feinstein.
Who?
Now it's you.
Oh, aye.
Mr. Leahy.
Aye.
Mr. Durbin.
Aye.
Mr. Whitehouse.
Aye by proxy.
Ms. Klobuchar. Aye. Mr. Coons. Aye. Mr. Blumenthal.
Aye.
Mr. Rono. Aye. Ms. Harris.
Aye.
Mr. Chairman.
No.
Mr. Chairman, the votes are 10 yeas, 12 nays.
The amendment is not agreed to. Senator Blumenthal?
Yes, thank you, Mr. Chairman. Here's another amendment that I hope maybe we can agree on. There have been a lot of references to the Mueller report and wanting to get to the bottom of how the Crossfire investigation began. You've indicated that you want to have someone here from the Mueller team. I think we need the unredacted Mueller report. I don't know whether you've referred to subpoenaing that full report, unredacted, but I have an amendment that would require the chairman to subpoena that report, and I ask that it be called up.
Without objection. Thank you. I'll make sure that anybody can look at the unredacted portions. I don't know if I don't know why it's redacted, but we'll all be able to look at it for ourselves. I'll pose the amendment. Clerk will call the roll.
Mr. Grassley? No. Mr. Corning? No. Mr. Lee? No. Mr. Cruz?
That's interesting.
Mr. Sack?
Lindsay?
Mr. Hawley?
I thought,
No by proxy.
Mr. Tillis?
No by proxy.
Ms. Ernst? No. Mr. Crapo? Mr. Kennedy? No. Mrs. Blackburn? No. Mrs. Feinstein?
aye?
Mr. Leahy? Aye. Mr. Durbin?
How did Grassley vote?
No.
I vote aye.
Mr. Whitehouse?
Aye by proxy?
Ms. Klobuchar? Aye. Mr. Coons? Aye. Mr. Blumenthal? Aye. Ms. Hirono? Aye. Mr. Booker? Aye. Ms. Harris?
Aye.
Mr. Chairman?
No.
Mr. Chairman, the vote is 10 yeas, 12 nays.
The amendment is not agreed to. Anything else? If you don't mind.
Be an investigation.
Oh, I'm sorry. Senator Harris.
Thank you, Mr.
Apologize.
Chairman. On behalf of myself and Senator Booker, I'm offering an amendment, HEN 20550, that would provide that the chairman would not issue subpoenas under the authority of this motion until the Senate passes legislation to meaningfully address the Justice and Policing Act, which, of course, is within the jurisdiction of this committee, specifically that it would address racial profiling and excessive use of force and other forms of discriminatory policing. And I request a roll call on my amendment. Thank you.
Thank you. I will move to table. The clerk will call the roll.
Mr. Grassley?
Yes.
Mr. Corning? Mr. Lee? Mr. Cruz?
What are we voting? I'm voting
Mr. Sack?
Aye by proxy.
Mr. Hawley?
Aye by proxy.
Mr. Tillis?
Aye by proxy.
Ms. Ernst? Mr. Crapo? Mr. Kennedy? Mrs. Blackburn? Mrs. Feinstein?
No.
Mr. Leahy?
No.
Mr. Durbin?
No.
Mr. Whitehouse?
No by proxy?
Ms. Klobuchar? No. Mr. Coons? No. Mr. Blumenthal? No. Mr. Rono? Mr. Booker? No. Ms. Harris?
No.
Mr. Chairman?
Aye.
Mr. Chairman, the vote was 12 yeas, 10 nays.
The motion is tabled. Anything else? I move to vote on Chairman.
Mr. Chairman?
I'm sorry.
I'm sorry. Can I be recorded on the Blumenthal amendment, present and?
Absolutely.
Yes. And yes.
Okay, so we have, yes, absolutely you can. So no amendments have been adopted, so I move to, I'm sorry, I apologize.
Mr. Chairman, the same for me on the Hirono
Absolutely.
amendment. Thank you.
Absolutely. I move to vote on the chairman's June 11th, 2020 motion to authorize subpoenas related to Crossfire Hurricane investigation. Clerk will call the roll.
Mr. Grassley?
Aye.
Aye.
Mr. Corning? Mr. Lee? Mr. Cruz?
We don't know for whom.
Sack?
Aye by proxy. Aye by proxy.
Mr. Tillis?
Aye by person.
Ms. Ernst? Mr. Crapo? Mr. Kennedy? Mrs. Blackburn? Mrs. Feinstein?
No?
Mr. Leahy? Mr. Durbin? Mr. Whitehouse?
No by proxy.
No by proxy?
Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Ms. Hirono? Mr. Booker?
No.
Ms. Harris?
No.
Mr. Chairman? Mr. Chairman, the vote is 12 yeas, 10 nays.
The motion's passed, and I appreciate the discussion, the debate. The motion is agreed to, and the chairman is authorized to issue subpoenas pursuant to the motion. The last piece of business will hold over the Attorney General legislation, Senator Lee. Hopefully when we get that next week, I promise you we'll have a vote on it. Now, on the motion to report the nomination of
We need Senator Hawley.
Corey T. Wilson to the United States Circuit Judge for the Fifth Circuit favorably to the floor. Clerk will call the roll.
Mr. Chairman?
No, we don't have the quorum.
Mr.
Is he
Chairman?
on the way?
He's on the way.
Okay, well, we'll vote, and we'll wait till it gets here. Let's vote. Some other people can go.
Excuse me, Mr. Chairman,
Unless you want to object. Technically, you want to go ahead and vote or not? You want to wait? Senator Hawley is on the way, and that would give us the necessary number. I could vote now, or I could wait. I
You
thought I'd
keep the vote
vote.
open. Keep the vote open.
Yes, I could. That's the point, so that people can go on about their business. But I won't do it if you don't want me to. Without objection. Okay, yes.
That will violate the rules.
Well, they just said it's okay to leave up.
It's a Senate rule, not a
Well, we're senators. And we run this committee. And as senators, we've said, we're going to let him come here. I assume in good faith he's on the way. Is that right? Is he coming? All right. If he doesn't show up, we'll avoid the vote. But we're going to vote, and we're going to leave it open so everybody else can go about their business.
Good.
The clerk will call the roll.
Mr. Chairman, I would like to seek recognition.
Yes, ma'am, you may.
Thank you. Mr. Chairman, in the middle of a pandemic that has already claimed over 110,000 lives, and that is not the end of it, this committee is moving forward with yet another nominee who is openly hostile to the Affordable Care Act. And Corey Wilson has not only called the ACA perverse and illegitimate, he has also stated that he wanted the Supreme Court to strike it down, and he may very well get that wish out of the Supreme Court. He apparently has no problem having millions of Americans without health care as a result of the Supreme Court potentially setting aside the ACA. And he must know that this kind of decision from the Supreme Court will result in the disproportionate harm that lack of insurance will have to blacks and minorities. Mr. Wilson lacks the judicial temperament to be a judge with a lifetime appointment. He has repeatedly demonstrated he is a right-wing politician in his voting record as a state legislator and in his public statements, even when he was not in office. He even admitted that he views himself as a partisan politician as a sitting state court judge. And at his prior hearing, I asked him why, as a state court judge, he hadn't taken down his highly partisan, offensive tweets against President Obama and Hillary Clinton. For example, one of his tweets claimed, "Crooked Hillary is the embodiment of corruption." Another argued, "Republicans are the adults in the room. Obama and company are increasingly shrill, dishonest, and intellectually bankrupt." Corey Wilson responded that he left those tweets up as a judge because he's an elected official as well. As a matter of fact, at that time, he had not been elected. He had been appointed to his judicial seat. He kept those tweets up to help him with his base when he actually had to run for his state judicial position. And he was saved from that situation with this nomination from the president. If he is confirmed to the Fifth Circuit, all signs point to him continuing his longstanding pattern of partisan actions and statements opposing health care, voting rights, reproductive rights, LGBTQ rights. The list goes on for Corey Wilson, and why should he change his views on any of these matters, especially from the security of a lifetime appointment? I will be voting against his nomination.
Thank you. And anybody else who wants to submit a statement, you're certainly, we'll make sure that's done. On the motion to report.
Senator Graham,
Yes, sir.
I was present, but I believe I may not have been recorded present voting
Okay.
for the subpoenas.
It will be recorded present.
Mr. Chairman, could I also be
Absolutely.
recorded as
Senator
present
Hawley
voting?
will be recorded
Subpoena.
present. On the motion to nomination of Corey T. Wilson to the Fifth Circuit, the clerk will call the roll.
Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Stan. Mr. Hawley.
What's the subject?
Mr. Tillis. Ms. Ernst. Mr. Crapo. Mr. Kennedy. Mrs. Blackburn. Mrs. Feinstein.
No.
Mr. Leahy. Mr. Durbin. Mr. Whitehouse.
No by proxy. White House says no by proxy. No by proxy.
On White House, no by proxy.
Yes, ma'am.
Thank you, Mr. Chairman.
Ms.
No.
Mr. Chairman?
Aye.
Mr. Chairman, vote is 12 yeas, 10 nays.
I think Senator Sass would like to be recorded as voting aye, present. Okay, thank you. Listen, I really appreciate the patience. Democracy's tough. I think the committee had a good discussion, and next Tuesday is going to be a long day, 2 panels, but hopefully it'll be a good day for the country. I look forward to it. Thank you all.
Wilson nomination
The
will be
Wilson will report favorably to the floor. Thank you all very much.
Thank you, Mr. Chairman.